Hello and very good afternoon, ladies and gentlemen. I hope everyone is doing great and still staying safe wherever you are now. It's great to be back again this week and welcome to the 16th episode of the Strata Talk Show, provided to you by the Excel Academy of Real Estate. So this Strata Talk Show, we will address issues and cases connected to the Strata property management with our various industry professional on every Thursday. Thank you so much for tuning in and for your ongoing support. Today's Strata Talk Show is about the Proposed Residential Tenancy Act, RTA. So do stay tuned with us for about 1 hour and feel free to ask your questions and leave them on the Facebook comment section below. Okay, so joining us with us today is our guest speaker, Mr. Patrick Sebastian. So a little introduction about our speaker today. Mr. Patrick is an advocate and solicitor by profession, having his own law firm, the Law Office of Patrick Samuel. And Mr. Patrick has vast experience in various fields of law, and his current areas of practice include land law, company law, and companies winding ups, bankruptcies, and commercial law. Mr. Patrick, it's a very honor to have you again this afternoon.
Right, thank you.
So, ladies and gentlemen, again, if you have any question to be asked to our speaker, Mr. Patrick, feel free to write your question on the Facebook comment below, and hopefully, Mr. Patrick will answer your question at the end of our session later. So, I think without wasting any more time, please join me in welcoming Mr. Patrick.
Right. Okay, thank you very much, Amir. Good afternoon to all of you all. Welcome to this particular talk today regarding the Proposed Residential Tenancy Act 2022. Now, whatever questions you may have, whatever answers I may give, is going to be not exactly based on the law, but it is going to be based on what is being proposed. So it's not a definitive answer. These are changes being brought about by the law in view of the fact that the government feels it is time to regulate the tenancy and leasing industry. Now, a little bit of the background. In Malaysia, we do not have any specific law which governs landlords and tenants. Leases, to a certain extent, are governed by the National Land Code. There are some implied terms and conditions which are stipulated in the National Land Code in the schedules at the back. These are more towards the duties of the landlord and the duties of the tenant. It does not attempt to regulate the relationship between the landlord and the tenant. Number one. Number two, there are individual statutes which to some extent touch or impinge on this landlord tenancy area. The Civil Law Act in Malaysia, for example, which introduces or which allows English law to be applied in Malaysia and continue to be applied in Malaysia, is one such example. The Distress Act, which talks about collection of rentals which are outstanding, is another example. But essentially, we need to understand that landlord and tenant comes under the broader spectrum of law of contract. So in other words, the foundational aspect of landlord and tenant relationship is that of contract. You have an offer, you have an acceptance, you have the consideration, you have the terms of the contract, which parties have to oblige. And fundamental to the law of contract is also what we call freedom of contract theory. In other words, parties are free to enter into contracts on any terms, provided those terms are legal. Now, we need to keep this in the background as we look into this proposed act and why there may be so much of objections to some of the proposed parts of the act. Now, many areas of contract law have been taken out from contract and put into specific areas of their own. For example, in Malaysia as well as in UK, we have the Sale of Goods Act, which deal with the sale of goods. So some of the provisions in the Sale of Goods Act will not be the same as your ordinary law of contract. We have Hire Purchase Act in Malaysia, which again is a form of contract, but once again, it is not the same as your normal contract. In England, they have the Landlord and Tenant Act, which governs relationship between landlord and tenant, whether it is commercial, whether it is residential. Therefore, in England, not only do you look at the terms of the contract, you also look at the provisions of the Landlord and Tenant Act, which deals with such relationship. Now, the big question is, how far should the government intervene? How far should the state intervene into this freedom of contract between a landlord and a tenant? How far should that be done? This is a question to reach a fine balance between freedom of contract on one side and protecting certain parties which are regarded as the weak party from being bullied or taken advantage of. Accordingly, this act, based on the comments by the government, attempts to protect parties' interests. Now, there are 7 key areas that I would like to touch upon as an introduction today. Because we only have 1 hour, I will just touch on these 7 key areas that will regulate this act. Number 1, of course, is the fact that it is only for residential tenancies. It will not cover commercial tenancies. Now, this may become an issue because if you are staying in a stratified property and yours is a SOFO or it is a SOVO or SOHO, where it's a mixed landlord, where it's a mixed commercial and residential, then the first thing that this act will have to do is to define what is the meaning of a residential tenancy. Right? So these borderline areas like SOFO, SOVO, SOHO, all these will have to be determined. Would they fall under residential or would they fall outside of residential? That is the first issue that needs to be dealt with. Number 2, under this act, a new Office of Comptroller of Residential Tenancy will be created. So just like you have a COB for strata properties, you will also have a Comptroller of Residential Tenancy to overlook, to supervise the act, maybe to come out with certain rules and regulations, and to implement other things from time to time. So there will be a new position created. This is the second point of interest. How this Comptroller of Residential Tenancy is going to take things forward is a very interesting aspect of the law we need to look at. What are the powers that will be given to him? Whether his powers can be challenged in court? Are they subject to judicial review? These are issues that are left to be seen. Number 3, we know that for every tenancy, there is usually a deposit which is collected. And this issue of deposit has become a major problem. There are some landlords who collect 3, 4, 5, even 6 months deposit. And of course, additional deposits for utilities like water, electricity, so on. Then, when the tenancy is over, there arises the issue of the landlord returning the deposit back. I can give you a good example of a case which I attended in the small claims court in the magistrates court in KL, where this person who was a tenant had returned the place, terminated the agreement, and the landlords were two doctors, husband and wife. And the landlord said that the condition of the place was not as good as it was at the time of handing over. And so they asked him to make good. I'm hearing this from him telling the magistrate. He said he spent about few $1,000s and made it good, and yet the landlords have refused to return the deposit. And he said it's not a big sum, but he said I need that money. I need to use it to pay a deposit for another place which I need to take. So was the landlord right in retaining the deposit and not returning it back? This can be an issue. So what is being proposed now? The proposal is for any tenancy falling under the Residential Tenancy Act 2022, the landlord can only ask for 2 months deposit and 1 month utilities. So it's 2 plus 1. 2 months deposit, 1 month utilities, and this money will not be given to the landlord, but this money will be handed over to the comptroller of residential tenancy. The comptroller of residential tenancy will then hand it over to as yet an unnamed independent agent. So take note, we do not know who this independent agent is as yet. But the comptroller of residential tenancy will take the money, hand it over to this independent agent, whose duty is to put that money into some fixed deposit or interest earning account. And at the end of the tenancy, the deposit will be refunded interest free. Right? It will be refunded interest free. The interest earned from the deposit will be used to fund the administrative work of that independent agency. Right? So this is going to be a big issue for everybody. But let me just tell you this, what is being proposed. The deposit will no longer be held by the landlord. The deposit will be held by the comptroller of residential tenancy, who will hand it over to an independent agency. That independent agency will invest that money into a interest bearing account, and the interest will be used to offset or defray the costs of that independent agency. Now, if the whole nation, everybody is going to pay their deposit there, that will be quite a sizable sum of money coming into that particular agency. What will the agency's function be? The agency's function will be to set up a database of all landlords and tenants. Now, in Australia, there is a database for landlord and tenants. So presumably a similar one will be coming here. There will be a database of landlord and tenants. The difference in Australia is, in Australia, landlords and tenants are blacklisted. If you have landlords who don't maintain the property well, who do not attend to the needs of the tenant, and who refuse to return the deposit, they will be blacklisted. Likewise, tenants who do not pay their rentals on time, or who do not maintain the property well, or who do not leave when the tenancy is over, they will also be blacklisted. So if you are a landlord in Australia and somebody wants to rent your property, you just check the database and you'll get all the relevant information. So it'll be something like, I assume, Secris, Citros, where you have an independent agent like Secris. They give you all the credit information is stored there, all the information is kept there, and people can make a search and people can find the information that they require. Probably we will have an independent agent similar to Secris will set up this landlord and tenant database to be made available to the public at some minimal cost. Any expenses due from the tenant to the landlord will be deducted from the deposit that has been paid. Right? So if the tenant demands back the deposit of 2 plus 1, the landlord can say, look, the condition of the premises is in bad shape. You need to repaint it. Painting will cost you another 2,000. If you don't want to paint it, we will deduct it from the deposit. So the controller of residential tenancies will attend to the disputes. Now, what happens if the disputes cannot be resolved? If the dispute cannot be resolved, they will have to go to the tribunal. I assume it is going to be the housing tribunal. Right? It will be the housing tribunal. So this is going to be a major issue for everybody. It's going to be a major issue for tenants and landlords. It may now become difficult to get back your deposit at short notice. Very often, tenants want their deposit back immediately so that they can use it to pay the deposit for another place, or they may use it for moving from one place to another place. They will need the money for that. But the way the act is, if there's a dispute, you have to go to the comptroller, and if there is a further dispute from there, you will have to go to the tribunal, and only at the end of the tribunal will you get back your deposit. And please note, all tribunal decisions are subject to judicial review. So any one party may decide to go for a judicial review of this. Now, there is a question already by one Tingfen. Is it when once it becomes an act, any attempt to bypass it will be against the law? That will be the whole idea. The whole idea is this act will regulate the relationship of landlord and tenant. Landlord and tenant will most probably not be allowed to go outside this act. Any clause in the agreement, any attempt to go outside the act will probably be regarded as illegal and as against the law. So this is to regulate. This is not an option. This is not suggestion. It is going to be an act. It will regulate. So it will supersede any other terms of the contract. So for example, if the landlord is asking for 6 months deposit, no, you cannot ask for such sums anymore. The tenant will be able to say, look, I'll pay you 2 months. Now the landlord is going to say, no. If you don't pay me 6 months, I'm not going to give you this place. You are free to look for other places. The tenant will be able to bring a complaint to the comptroller to say that I want this place. We have agreed, but you want 6 months. And the law says you can only take 2 months. Right? Now, so point number one, this only covers residentials units. It will not cover commercial units, and that puts Soho all right at the border. How are they going to be determined? Point number two, as I've said, is that 2 months deposit and 1 month utility only. Nothing more than that can be demanded. That is a ceiling. And this money will not be given to the landlord. It will be given to the controller of residential tenancy, who will hand it over to an independent agent to supervise this. The independent agent will put it into an interest-bearing account, and the interest will be used to defray the expenses of that independent agent, like secrets of citrus. And the independent agent will set up a database of landlord and tenant. So you may have your good landlords and your bad landlords, and likewise with the tenants as well. The next point is that the money from this deposit will be used to deduct any expenses which ought to be borne by the tenant. For example, outstanding electricity, water bills, or any damage to the premises. If there is a dispute, this dispute will have to be brought before the comptroller, and if the dispute cannot be resolved by the comptroller, then it will have to be brought before the tribunal. This will delay the return of the deposit. And then the next point is that regarding rent control, the Act also attempts to restrict the number of rent increases a person can make. So landlords will suffer here because you cannot revise a rental as and when you like. It will restrict or limit the number of rent increases. Currently, there is no limit. Each time you renew, parties can agree to 10% increase or such sum as may be agreed by the parties. But here, it will attempt to limit the number of rent increases. It also will attempt to limit the rate of increase. Whether it's going to be 10% or 20%, it is going to limit. The comptroller will come out with rules and regulations on this point. So this is another area that we need to take into account. Finally, last but not least, I'm not sure whether many of you are familiar. If you have a fixed term rental, let's say you have a 2-year rental agreement with someone, fixed. And after 1 year, the tenant wants to terminate the agreement and leave the place. Now, according to the law as it stands today, where it is a fixed term tenancy and the tenant wants to vacate prior to that, he will have to pay the rental for the remaining part of the tenancy. So, for example, assuming you're renting premises at 5,000 ringgit per month and you have a 2-year agreement, and after 1 year, you have bought your own premises, so you wish to terminate this agreement. You think you'll give 1 month's notice, or maybe 2 months' notice, or you think you're being generous by saying, I give you a 3 months' notice that I will be vacating these premises. Now, number one, you are in breach of the law because it's a fixed term tenancy. The landlord can forfeit your deposit. Number two is you are terminating after 12 months and you're giving 3 months notice, which means 15 months instead of the 24 months. The landlord is still entitled to the remaining 9 months rental. Now, why is he entitled to the 9 months rental? This is based on the law of contract. The law of contract says that when one party has breached a contract, the other party is entitled to damages. Right? Now, damages can be agreed by the parties. The parties agree how much to pay, usually the court will respect and honor that. But if there is no provision, then according to the law of contract, the role of damages, the role of compensation is to put the innocent party into the position he or she would have been in as if the contract had been completed. I repeat, the role of damages or compensation in the law of contract is to put the innocent party into the position he or she would have been in as if the contract had been completed. So in this case, if you have a 2-year fixed contract at 5,000 ringgit rental per month, the landlord is expecting 120,000 ringgit at the end of 2 years. If you were to terminate the contract after 12 months, having paid 60,000, and giving 3 months notice, another 15,000, you have only paid 75,000 out of the 120,000. And so, the landlord is entitled to the remaining outstanding rental. Now, this is regarded by many as being unfair and unjust. Because on the other side of the law, there is also in the law of contract a rule which says that an innocent party must mitigate his loss. In other words, he or she must try to reduce his loss. So if that particular premise is very tenantable, is in high demand, and is easily able to be rented out, why should the former tenant pay for that amount when the landlord is going to rent it out again and you will end up getting a double rental, literally? It may be different where these are difficult places to rent, and so the landlord will have to go and start all over again looking for a tenant. But there's this conflicting view in the law of contract. So now, this act proposes that the landlord will not be able to claim anymore for the remaining part of the rent. He cannot claim, in short, the landlord cannot claim for unexpired term. Right? The landlord cannot claim for unexpired term. So these are the basic provisions of this act. Okay, these are the basic provisions which we need to know at this stage. Of course, we have a seminar coming. If you attend that seminar, then we will give you case laws on the existing law and how this act will affect those case laws in the future. All right, that is regarding the provisions. Let me very briefly, in the next 5 or 10 minutes, touch on some of the difficulties and the challenges that we are going to face. Number one, many associations in Malaysia, including Rta and others, have argued that increasing of rentals, the rate of increase should be determined by market forces. They argue that the situation in Malaysia is such that one size cannot fit everybody. If you're staying in the heart of KL, there may be great demand for rented units, and you may be able to charge high for rented units. But as you go outstation, we just go out a little bit, rental rates drop. That's the problem. That's first problem. It's not the same everywhere. Of course, KL is expanding, Klang Valley is expanding. There are many pockets of areas where rental goes up. Areas like Kajang, rental has gone up. Even Semenye, prices of property have gone up. Sungai Long, Cheras. But when you look at places like Shah Alam, Bangi, Sri Kembangan, they've not gone up at that kind of same rate. Unless there is a LRT or MRT nearby, then prices shoot up like Putra Heights. Prices shoot up like nobody's business. If you go to Klang, Klang South is developing with botanic gardens and all the others. They are developing. So different places are developing at different rates. So you cannot have one size fits all. Number one, this is the first complaint, that there's no flexibility. They're not looking at different aspects. What was proposed by Rta was that the Residential Tenancy Act should be applied to the B40 class. In other words, B40 is regarded as low income rental, and low income rental is defined. Uh, there's no definition of it, all right? There's no specific definition, but there is a regulatory impact statement, we call it. Regulatory impact statement. The regulatory impact statement says low income rental means 750 ringgit or below. So any rental which does not exceed 750 is regarded as low income rental. So they are saying, Rta is saying that this act should be restricted to that category. Above that category, landlord and tenant should be free to negotiate the terms. The deposit of 2 months plus 1 is also seen by many as being insufficient, because again it doesn't address the situation that in some places 2 months deposit may not be sufficient for the kind of unit that you may rent. Remember, some bungalows in Taman Tun Dr. Ismail are rented out at between 12 to 20,000 a month. I know a few landlords and a few tenants who are staying in Taman Tun Dr. Ismail bungalows, depending on the land size and all that. They are paying between 12 to 20,000 a month rental. They're huge bungalows, right? Now, to the landlord to say that I only take 2 months deposit and 1 month deposit for water and electricity may be a little bit ridiculous, so to speak. Surely, in such kind of places, they will want a higher deposit, not just 2 months alone. After all, this deposit will be refunded to the tenant at its due time. So there is also complaint about this. The third issue is, why should the controller of residential tenancy or the so-called independent agent, why should they keep the money? Why should they keep the money? The money should be kept by the landlord and it should be returned back to the tenant as soon as the tenancy is over, provided there is no dispute between them. Now, if you go and start applying to the comptroller for the money, and then they will say, I want a letter from the landlord saying no objection, the landlord just has to throw, and if there is some kind of bad blood between the landlord and tenant, the landlord can easily just throw in and say, no, I got the following complaints against the tenant. And that will delay. And then from the comptroller, any dispute goes to the tribunal. So that's going to be even further delay to a money which, barring anything else, rightfully belongs to the tenant and should be returned to the tenant. The justification that, oh, we need this money to be put into a interest producing account so that it can defray the cost for that independent agent doesn't hold water, because such agencies should be funded from taxpayers' money. To come out with a database for landlord and tenant, right? Should be funded from tax-based money, should not be taken from this interest. It's not fair to the tenants. So these are some of the issues. They are saying even the rate of increase of rent and the number of rent increases, they say, is not fair. And the last part regarding the unexpired term, there is a lot of dispute still going on about that. So, because like I said earlier, if you are staying in a city where when you vacate halfway, it is easy to get another tenant to come in, then the landlord doesn't suffer loss. The landlord need not retain the unexpired term. But if you're talking about a place where it's not easy to rent and the tenant suddenly leaves halfway and the landlord will have difficulty finding a new tenant, then for fixed term contracts, it's only fair that the tenant bear the full brunt of it all. So basically, in outline, this is what I've got to say about um, the proposed act, the Residential Tenancy Act 2022. So if any of you have any questions, then we will start dealing with the questions. Thank you very much.
Okay, thank you so much, Mr. Patrick, for sharing your perspective on this topic of the Residential Tenancy Act. So, Mr. Patrick, can you see the questions on the private chats next to you?
Right, I can. I can. I
Okay,
see there's a question
so
from Lisa.
yeah, sure. So maybe I can read the question, so you will answer after that. Yeah.
Sure.
So the next question, I believe you have answered the first question, and the next question is from Amiza. The question is: the landlord will be hit by a double or triple whammy by this act if passed. House ownership for investment may suffer a major drop. Assuming there is no dispute, how long will the refund to the landlord take?
Okay. Um, Now, to answer this question, there are two parts to the question. Yes, this is a major, it is likely to have a major impact on the industry, right? It will be likely to have a major impact on the industry because many of the people who buy properties buy them as a form of investment. So, if they're going to be restricted by this kind of conditions, terms and conditions, then it's going to become a problem. Now, the next part of the question, assuming there's no dispute, how long will the refund to the landlord take? Now, this is anybody's guess because it's not put into operation as yet. There are no rules stating when this is going to happen, right? Now, whether they will refund it directly to the tenant or they will refund it to the landlord and the landlord has to return it to the tenant is anybody's guess. Those are the mechanisms that have yet to be worked out. These are only the principles. Now, if the money is going to be returned to the landlord and from the landlord to a tenant, that's going to take time. Now, if the money is going to be returned directly to the tenant, then maybe it might be faster, assuming there is no dispute, right? And since the money will be put into some interest generating account, then they have to deal with that aspect as well. Okay, that's one thing. Okay,
Okay, thank you so much, Mr. Patrick. I hope it's answered your questions, Amiza. And the next question is coming from Rida bin Anis. The question is, if KPKT is going to collect the money, who is going to make the enhancements or repairings?
okay. Now, this deposit that is paid is only for the fact that there is an undertaking by every tenant that he will return the house or the premise to the landlord the way in which it has been given to him, fair wear and tear accepted. In other words, if I've been renting the place for let's say 6 years, 2 years, 2 years, 2 years, you cannot expect me to return the place in the same way exactly as how it is. But if I punch nails into the wall and I've did any kind of temporary extensions, awnings I put and all these things, I should remove all of them. I should patch up the holes in the wall. I should paint back the place and return it back to the landlord fair wear and tear. Let me tell you, in Australia, there's no such thing as fair wear and tear. You have to return it exactly as you took it, and you have to pay 6 months rental deposit in Australia. So you have to make it good as it was when you took it, right? Now, so this money is only for that purpose. This money is not for the normal repairs which either the landlord or the tenant has to do. Now, we understand that if a repair arises from wear and tear, let's say, for example, basically your tap head bocho, your tap head is leaking, right? Your power points are not working, your switches are not functioning after some time. That will be the tenant's job. You have to repair it at your own expense. On the other hand, if you find that the main connections are gone, the main wirings are gone, some structural damage is there, then this will be the landlord's responsibility. This is general, but this will be subject to how the landlord and the tenant draw up their agreement. Again, this is a very good question because it brings to the open the issue: will the controller step in to determine who is going to repair, landlord or tenant? That will be another big major issue to be determined. So it's a very good question to ask, right? This will depend on the subsequent regulations that they will have to draw up on this matter.
Okay, thank you so much. Okay, coming to the next question from Fikria binti Arhab. Hi, Mr. Patrick. If the legislation aims to regulate rental rates of public housing premises, would it contradict any current bylaws or agreements that prohibits the renting out of public housing projects?
Yep, I'm quite sure that this will not step into that territory because, like low cost and medium cost houses, you're not supposed to rent it out to anybody. Any such rental is already illegal. So, an act cannot attempt to regulate what is illegal. So, that will remain illegal. In fact, there is already laws which says that if they find that a public housing like PPR and all that is being rented out, they will forfeit the property. You see, that is supposed to be the law. Okay, this act does not seek to touch on those public housing and low cost housing. It only seeks to touch private housing agreements.
Okay, that's great. I hope it's answer your question, Miss Fikria. Okay, so we have another question from Sean Lee Guapin. Hello, sir. I have a question. If no additional expenditure were paid, would the security deposit be refunded to the tenants after the leasing agreement expired?
Yep. According to the proposed act, it says that if there are no disputes, um, the deposit will be paid back. Okay, interest free, of course, at the end of the tenancy. Yes.
Okay, so the answer will be yes, yeah. Okay, so the next question is from Nerang bin Putih. Hello, Mr. Patrick. One of the issues we see with this RTA is that neither the landlord nor the tenant is equal in status, giving one more bargaining leverage over the other. This has the potential to generate major problems since one side may not be adequately protected. So, what is your opinion on this, Mr. Patrick?
I will agree. The first thing that has been done is this act cannot protect everybody because one size does not fit all. That's the first thing that we have to take note of, right? One size does not fit all. They are not even looking at the location. Where there is a great demand for premises, for rentals, right? The landlord always has great bargaining power. Let me give you an example which I myself experienced many years ago when I was in Penang. I saw a nice semi-D house at Tanjung Bunga Road, and I asked them to rent it out to me. At that time, they rented it out to me at 700 ringgit. The reason being, there were only 5 houses there. 3 houses facing the main road were all abandoned, were literally abandoned. Nobody was staying there. So this place was 4,000 square feet. It was rented to me at 700 ringgit. 1 year later, everything changed because people saw that I was renting this place. The next MED, the next unit was empty, but it was taken over by a bakery. So suddenly it became popular. Suddenly, when the landlord told me, okay, if you want to continue, it's 1,500 ringgit per month. From 700 to 1,500 ringgit. That is a straight jump, such a major increase. Why? Because the demand is there. Now, if you go to Kulim, for example, in those days, you go to Kulim, a place like Kulim, not very far from Penang, but you go to Kulim, you can get a double-story corner house rental for 200 ringgit because nobody wants to go there. If you're going there thinking that you're going to work anywhere, forget it. The only people who live in Kulim are people who are either school teachers, government service workers, or those who are retired. Many people retire from work in Penang, government service work in Penang, they buy a house in Kulim, they go and stay there. So, in that place, the landlord cannot make great demands, right? You only get $200 rental. And if you make too much noise, the guy is going to leave that place, and that also you would not even get. So, I think to put a flat rate across the board for everybody is not a very viable thing. So, it will lead to a lot of problems. It will create a lot of issues. In some areas, the landlord will not be protected. In some areas, the tenant will not be protected. So, there is opportunity for abuse. But of course, organizations like Rta and all that, they are mostly in the Klang Valley. So they're looking at perspective from the Klang Valley, where they're saying, well, why not we do it this way? For those units which are low cost rental, protect the tenant. But for those which are above, let the market forces determine the prices, the terms and conditions. That's what I can see.
I see. Okay, so we go to the next one. Okay, I guess this is the same questions. Yeah, the last one from my son bin Noor. Can the RTA provide landlords some flexibility while yet safeguarding tenants through a more simplified legal framework?
Okay. Now, according to the government, they had taken a survey, and in this survey, they said they had got all the relevant information, and this survey formed the basis of this act. However, when we look at the percentage of people, just give me a minute. Um, okay, yeah, I got the figures here. Out of Malaysia's 32.4 million population, only 3,100 odd people responded. No, the 32.4 million, 3,000 old people responded. This is what kind of percentage? It's not even 0.01%. It's even less than that. 3,000 opposed to 32 million. How can you come out with an act based on 3,000 people's views? Right? That is the first problem. Number two, they did not, right? They did not consult the bigger organizations. Number three, the survey was only done in Putrajaya, Klang Valley, and Selangor. Right? So they didn't include other places. Number four, uh, out of the 3,000, roughly two-thirds were tenants, 1,000 were landlords. Okay? So not much to be taken from there. Okay? So we are looking at an act being based on very, very minimal input. Very minimal input. Right? Putrajaya, KL, Selangor. I mean, that dynamics of this place is not applicable to other places. I can tell you, you can check for yourself. Compare rentals in Kajang with Bangi. Compare rentals in Semenyi with Bangi, side by side towns. Next to Semenyi is Bangi. I've got a lot of cases from Semenyi. I also do cases from Bangi, land matters. I can tell you, if you take a drive in Bangi area, you will see many of the low-cost flats are actually abandoned. Compare Klang with Shah Alam and PJ. Compare the rental rates. So you take from KL, Putrajaya, and you're not even looking at Klang, you're not looking at Shalam, you're not looking at Bangi, you're not looking at these towns. So where do you get a balanced view from? Right? Where do you get a balanced view? And then you should have different stratas. Those are paying rental below 1,000. Those are paying 1,000 to 2,000. Then 2,000 to 3 or 4,000. Then 5,000, 10,000. Those are bungalows, right? So you must get different stratas of tenants and landlords. What are the needs of a landlord, like I said, who owns a house, a bungalow in Taman Tun Dr. Ismail and or in Bukit Damansara, and who rents it out for 20, 30,000 a month, or even in Bangsa, some parts of Bangsa. What are the concerns of the tenants in those areas? What are the concerns of landlord in landed property and tenants in what we call stratified properties, for example? There's a world of difference between the needs of these people. And all this was not done. All this was not done. Based on a survey of 3,000 people, they have come out with an act and limited to KL, Klang Valley, Putrajaya. Now, I'm sure you'll agree with me. This is not an efficient way, it's not effective, and it does not reflect the wishes of the majority either. I mean, that's what I can say, right?
I see. Okay, thank you so much, Mr. Patrick. Okay, I think this is the first question that you have answered
Yeah,
before.
yes. I've already
Uh,
answered this. Never mind.
yeah,
I think Ms. Tan Ting Fen, I've answered this question, right?
yeah,
Once it becomes an act, you cannot go against it. Simple as that. Anything that you do which is against it will be in breach of the law. Yes.
I see. Okay, thank you so much, Mr. Patrick. I guess there is no more question. So before I end, maybe you can conclude something, Mr. Patrick, on today's topics.
Well, I would suggest actually that the if you are a property agent, if you are a property manager, or even a developer, I would think that you should actually write into the Kementerian Perumahan and give your views. Give your views as to the viability of this act and what are your concerns regarding this act. Like one of them wrote earlier, right? This is definitely going to affect the market. You see, would a landlord be prepared to rent out his premise just for 2 months deposit if it is a big sprawling area, a house, semi-D bungalow house, or even one of those big link houses where 2 months rental will definitely not be enough to cover any damage that is likely to take place, because the act also needs to deal with one other thing. If at the end of the day the tenant does damage which exceeds the 2 months rental deposit, what are the remedies of the landlord? You see, the landlord's concern is very important because that property is an investment. You cannot damage it, because if you damage it, then it has to be repaired before it can be rented out. And if the repairs are going to take another 2-3 months, that is a loss of income for another few months. There's out of pocket expenses, right? And if not only your unit, if all the other units experience similar things, it is going to be a problem. Now, those who are managing apartments should also write, because if you're one of those property managers who are managing condominiums, right? One of the important things that you want to see is to make sure that most of the condominiums are occupied, the units are occupied, or they are rented out very well, so that and tenants are paying well, and so that it enhances the value of the condominium, right? It enhances the value of the condominium. So this is an important thing. So when people come to view, if they're going to see your neighbor's condition is so poor, neighbor's condition here is so poor, they may be reluctant to rent the place from you, because I'm not just moving into one unit. I need to know who my neighbors are, what kind of condition it is in. So it is bad. It is bad. So I would urge property managers, developers, and you know, real estate agents, all of you to actually write in, because as estate agents, your income is not only from sale of property, it's also from rental, right? And you will be affected because the property market drops, your income also drops. So you all should actually give your input on this area. Tell the government what you think about it. Make sure the government rethinks before it becomes law. Very often the government has a habit of introducing the law first, making changes later. And then by that time the minister changes, the next minister is not interested. Then you have a nightmare. Thing. Alright. I mean, we have seen this with the Strata Title Act. We have seen this with the 2007 Act, Building and Common Property Management Act. We have also seen it with the Strata Management Act 2013. So, but let's not wait for this kind of disasters to happen, right?
Okay, thank you so much, Mr. Patrick, for your advice and your perspective on this interesting topic, which is Residential Tenancy Acts. Thank you so much, everyone, for tuning in on our Strata Talk Show this afternoon. So with the end of our Q&A session just now, so that's the end of our episode 16 of the Strata Talk Show. Thank you so much, Mr. Patrick, for speaking with us today.
Welcome. It's welcome.
Okay, so before I end, I would like to invite everyone to attend Mr. Patrick's actual seminar on this topic, the Residential Tenancy Act, Issues and Challenges, on the 28th of April, which is Thursday, from 10:30 to 12:30. So if you like to register and to hear on Mr. Patrick's seminar, please contact the number on below and register with us for this seminar on Residential Tenancy Acts, Issue and Challenges by Mr. Patrick Sebastian. Okay, thank you so much, Mr. Patrick. Hope to see you on the next episode. To everyone, thank you again. Stay safe and goodbye.
Thank you, Mr. Amir. Thank you, everyone, for joining in today. Have a safe day. All right. Bye.